Tice Maddox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Maddox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen. It's your favorite solicitor again, Justice Madforo. I'm the principal of Tice Maddox Solicitors. This program presents the right information for you to key on, and then signposts you to Tice Maddox Solicitors. It may not be you that needs this advice. It might be someone dear to you. It might be your friend, your colleague, your neighbor, your classmate, your schoolmate, whatever it is, extended friends, whatever it is that may need this information. Remember that an information you give to someone is much better than giving the person fund, because you have directed them to the right place, less stressful for them, and the result they seek, they get it. That is the most important thing, ladies and gentlemen. This is not a legal advice program, but it's a program that signposts you, brings up your consciousness, kickstarts your consciousness to know the right thing to do. If you're sleeping on your right, to wake you up and to point you to the right place. And then when you come to Tice Maddox Solicitors with the contact details you can see displayed on your screen, and then we will take time and analyze your case. Take time and analyze your case. We are so thorough that we will never, ever trade that process for anything. We must sit down, take time, explore your case, ask you deeper questions, things you think does not matter. We will pick them up, just like the microscope. It picks up certain things you can't see with your naked eyes. We will pick those up, and trust me, it might be the icebreaker in your case. And so we do that to make sure that you have the best representation. And then we specialize in areas that you heard in this program, and also in other areas, from immigration to the employment to family to criminal matters. By the way, this firm has legal franchise to represent you at the police station free of charge. If you are being invited or arrested for benefit fraud or anything to do with HMRC or to do with Department for Works and Pension, in relation to your claim for benefit, whatsoever it is, either in Job Center Plus or Job Center or wherever it is that is appropriate for the Department for Works and Pension to investigate you, then you can show it's all part of police station work. We will represent you free of charge. Some of you go to speak to these officers. They are powerful and they have the backing of the law to charge you. So don't take it lightly and you walk into that interview with them without having a solicitor, because your interview will be done under caution, and therefore it is equivalent to a police station interview and in all criminal matters, and you can all get this advice and representation at the police station or at that job center free of charge. So therefore, this firm gives it to you free of charge. You don't pay anything to it. Government has given you that access to justice by having the right solicitors to advise you from the initial beginning. That is why this government wrote that Access to Justice Act, to enable us and instruct firms like us, instruct people like me, Tice Maddox Solicitors and Justice, are qualified and competent to represent you in those manners and guide you along the way, whether in the magistrate court, in the crown court, subject to means testing, and all the way to other courts of record. Ladies and gentlemen, that's what we do. Also, family matters, as I mentioned, litigation matters, all manner of litigation in the county court upwards to the tribunals, immigration tribunals, employment tribunals, and you can have us to represent you. We got your back. We got you. That's what we do, because we are set up for you, nothing more. Once we take you in, you become a valued client. As a valued client, we'll give you the best representation and advice. Remember, any advice we give you in the office is the best advice you could ever get anywhere. And you can run with it. You can sure bank on it. And you can sure see that it's profitable for you if you follow our instructions. Ladies and gentlemen, today I'll be talking on employment law. And my topic today is sex discrimination. I'll be talking on employment law. And my discussion today is sex discrimination, or perhaps sex discrimination. While I'm discussing that sex discrimination, I also include harassment into it. but I'll be mostly talking on sex discrimination, and I'll use the word sex discrimination updates because I've discussed sex discrimination in the past few years on the show. You can watch some of them on the YouTube. They're there. So there are a lot of updates now. So sex discrimination updates, ladies and gentlemen. Now, why did I choose this topic today? As I told you before, I am a solicitor of the Supreme Court of England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria, whereby it means that litigation advocacy are part of me. A part of this firm. This firm is anchored and built on a solid foundation for litigation, solid foundation for advocacy. And because it is my calling, it is my trade, it is my stocking trade, and therefore advocacy are my skills. When I represent you in magistrate court, in the tribunals, immigration tribunals, employment tribunals, in all matters you're going through on other tribunals, when I represent you in the county courts, both in litigation, and I come to court to I do the trial for you, conduct the trial, conduct any hearing for you, you are sure to have the best representation and you're sure to have the best advice. And these litigations vary from different areas: contract law, commercial disputes, in commercial leases that you have, a dispute, more especially contract law, contract with dispute in properties, dispute in ownership of properties, or dispute in beneficial ownership or legal ownership of that property or that item, or whatever it is that you dispute with someone, a dispute in respect to agreement you've made over a business venture which has failed, which has succeeded, in respect to the person who is going to be responsible for the profit, responsible for the liabilities of that business or that company or that venture, and there's a dispute in there in respect to the profit, what you get, what the person get, how the person has liquidated the company, in respect to so many things: credit card dispute, bank dispute with whoever it is, and this matter needs to be addressed by the court of competent jurisdiction and court of jurisdiction to deal with that matter. You're sure to have tax matter solicitors behind you to represent you. Sometimes when we do pre-action protocols in civil matters, we succeed for you without even necessarily going to court, because ideas and arguments are being funneled into that in such a way that the other party will see they have no case to follow through but to give up and agree. In that case, you win your case without going to court. How about that? Today, I'm discussing, and the same approach funneled down to employment matter I'm discussing today, sex discrimination. Sometimes you don't need to go to tribunal to ventilate your sexual allegation against your employers or sexual allegation against your employee. So whichever way it is, you don't necessarily need to go to the tribunal to finally ventilate it, or to get your decision, or to get your response, or to get justice, or to get fairness. Sometimes it could be done by pre-action protocols, but also be done by pre-action protocols in such a way that you have invited the person and to agree without you going necessarily to court, especially employees who are complaining against sexual discrimination against their employers. You could have your result without necessarily issuing that Form ET1 or expecting Form ET3 from your employers to respond, either to agree or to dispute. Of course, you know your employer is not going to endorse your application. They're going to definitely dispute it. And they're going to definitely put forward defenses against you. And therefore, your case opens a whole wide new range of litigation, a whole wide range of hearings upon hearing, preliminary hearing, case management hearing, trial hearing, adjournment. So you get all that. But what we do from the beginning, especially, because if you've gone too far, you may want to return back to tax matter solicitors to pick it up from there and see how we can now get this matter and get the other party to agree. We negotiate. We are a commercial acumen firm. What does that mean? And I, Justice Madfro, a trained and a seasoned lawyer, a seasoned solicitor and barrister, not only arguing the law for you, I'm also informed commercially to ensure that whatever the commercial value of your claim, that you can have a win-win approach to it. And that's what I do for you. So it's not, you could go to a firm that just, okay, let's go to court for you and let's proceed on this. Remember, all these options I explore in your best interest. What will suit you more? What will give you less, stress? What will give you less, financial constraint? What will give you less, stress for you? I'll inject all that. When all that fails, obviously, we will go further to now get you the right decision and success that you require in the employment tribunal. Now, for whatever claim that you have against your employer, of course, the first stage for us is to make a written complaint and lodge that complaint to your employers. That's the first stage for us. In certain circumstances, though, you don't need to take that stage. You go straight to the employment tribunal. So there are certain circumstances also where you can have to follow that. Now, there are also ECAS principles and guidance of that. ECAS principles and guidance are not binding on the employer. What they do basically is just to show that there are steps you need to take and need to abide on. If the employer or employee fails to do that, that does not necessarily kill off their case. It simply means that once you succeed in this, the tribunal will have insight of the fact that this procedure was not followed. And that may reduce a little bit of your word or reduce a little bit of your case. You know, or if you have one or two claims that goes on together in that claim, that could be subjected down to one claim and leaving the other. But basically, it will not rubbish your case. Your case will be heard. The substance of your case will be heard. And therefore, that's the first stage if you have a sexual discrimination claim or complaint against your employer. Now, the substance of my discussion, away from all that, now, first thing first is that just like a police station, just like a criminal matter, the first stage in criminal proceeding to achieve success is the police station. The foundation is the police station stage. So if the police officer gets his interview right against you, subtly, that's why I said don't go there without a solicitor like us following you to the police station, and it's free of charge. You have a franchise to represent you or anybody you know free of charge. So why do you want to risk the very important foundation that's required to set you free and you just walk in there yourself? You can do that. Taxpayer solicitor will sort it out in the police station upwards. Now, the same foundation is your complaint procedure in sexual discrimination matters. Remember, I'm talking sexual discrimination matters. There are other discrimination matters. There are maternity discrimination matters. There are racial discrimination matters. There are so many discrimination. There are disability discrimination matters and all that. So I am specifically funneling and jogging your mind on sexual discrimination. Why am I saying that? Because in employment environment, these are rampant situations and events and issues. They consistently come up in workplace environment. Do you know that even though that you work and go back home, your majority of your time is spent at work, and valuable time too, because your life at home depends on your work, on what you do at work. So therefore, your economy to succeed and to live is from your workplace. So it's a very important place in your life. And because of that, and there's a lot of laws and guidances in your workplace. Sometimes, you fall out of it. Sometimes someone falls out of it against you. So that does not mean that you have no remedy. The remedy is the law providing you for these options to take into account these options if you have been found that this claim arises and there is substance to that. We will process what substance is it. And that's why I'm saying to you today that in employment sexual matters, first of all, you raise your complaint. The complaint, that's why I'm telling you now, just like the police station stage, you don't raise that complaint yourself. Taxpayer solicitors will articulate the complaint in such a way. Remember, I don't know to say this. Remember that what I'm saying here is that when we prepare that substance at the early stage, remember, because it's a firm that have looked in the future, we will look beyond the complaint. We are not looking beyond that. We're looking beyond agreement now. We're looking beyond success, win-win situation for you, commercial success for you, whether it's commercial or whatever other remedy that is sought, that you are at peace, that you are happy, that your worth is also restored back to you if you go through sexual discrimination or sexual harassment in your workplace. So these are two fused concepts that you may want to go through: sexual discrimination or sexual harassment. So either of these two come into play a part. Especially, I am not just restricting this to only females. So some people, when they hear sexual harassment, they feel it's against females alone. These are both genders, both male sexual discrimination or female sexual discrimination. But most of you have this concept that is mostly the female discrimination that this applies to. But be it as it may, if it's the female or if it's the male, there is also a remedy for you. And that remedy is to, first of all, articulate your complaint. The articulation of your complaint enables your employer to understand straight up what the issues are, what the grounds are, what your evidence are, and they are watertight proof. I can assure you that once they consider that, they will enter into a negotiation, either whatever remedy that you are looking for, to achieve that remedy that you're looking for at the early stage, saving your pain, saving your stress, saving you cost, saving you unnecessary hearing dates, saving you inconvenience, saving you quite a lot. And because it's prepared by a solicitor who understand employment procedures, who understand what it takes to succeed in sexual discrimination cases. Sexual discrimination cases are very difficult to prove. They're very difficult to prove. At the same time, they're very easy to prove. They're the easiest to prove, but they are most difficult as well to prove. That's why the percentage of cases in employment tribunals that come under sexual discrimination cases fails. Why? Because from the beginning, they're not yet articulated properly well. So because the employee just sit down in a bed and just type letters and send out. Because at that point, she's hurting, he's hurting, he feels I need to ventilate it. The internal manual, employer's manual says raise a complaint. I'm raising it now. No, you are raising legal issues. And so that's why you should pause there and meet a solicitor who will take this concept, your circumstances, the issues down in proper perspective, and then write it out, articulate it in such a way that once your employer receives it, he knew once and for all immediately, this is an input of a seasoned solicitor. They will know that. The language alone will show. The wordings will show. The articulation will show. The chronology will show. The facts will show. The evidence will be projected to, will be pointed to, and they will look at it. And the summary concluded. And they will look at it and say, this is what we may lose this case. And then they have their own to discuss with the team and discuss and say, how do we ameliorate this issue? How do we settle this issue? How do we address this issue? How do we now compensate this employee? How do we now challenge if the case be? So the question now would be how you articulate it, how you put it forth. So if you have any or you feel that there is sexual discrimination against you. Now, sexual discrimination does not only apply when you're already an employee. Sexual discrimination can apply also when you're applying for a job. Sexual discrimination can also apply whether you're an employee or you're an agency worker. Sexual discrimination can also come in. So sexual discrimination is basically to restore your human worth. That you will be looked at based on your intellectualism, based on your competence, not against your sex. Your sex should not hurt you to get a job. Your sex should not and must not hurt you to keep your job. So it will only enable you. Your sex is only created because you are not the maker of your sex. So you were created the way you are. And as a result of that, you have the competence and you have the opportunity to explore who you are and succeed and grow in your employment, either as a self-employed or agency or employee or whatever category of employee that you fall yourself into, that you are able to actualize your self-worth. So because when you are discriminated as a result of your sex, you question your maker, you question why you are a woman or why you're a man, you question your existence, you question your capability, you question your self-worth, it reduces you down. And because you are talked down upon, and then not even at that, either you are harassed as a result of the fact that you're a woman or a result of the fact that you're a man, you're sexually harassed by your employers, your fellow employees, or by even, not just that, the customers of the employer. The customers of your employer can sexually harass you, can sexually discriminate against you. So these are the concepts that we will pick up from. Because we deal with that, we'll be able to advise you properly, ladies and gentlemen. When I go to the employment tribunals, I see people standing on themselves to just address the judge. And I sit back waiting for my case to be called. And what I could hear is a litigant in person representing himself or herself in a sexual discrimination matter. And he knows very well it's a technical area. And he's there talking by himself. I'm not saying that you're not intelligent enough to represent yourself, but there's a reason why you have seasoned solicitors. There's a reason you have seasoned experts. And though you cannot substitute their expertise with your own common knowledge. You cannot. You could try, but you cannot. because there's a purpose why the training was implied and the practical experiences that we've gathered over the years, all to funnel to represent you. And I sit down watching, and then, the litigating person is addressing the court. I just cringe myself and say, I wish this person had just sought legal advice a little bit before talking here. Because you could see that either talking about a concept, they are driving emotion first before the legal issues. So when you drive emotion forward too much, you hide the legal issues. And the court deals with the legal issues, not your emotions. Emotions are good to apply to show that you are sincere sometimes, to show that the facts are real or the fact actually did occur. But when the emotions are beclouding a lot of the legal issues, the court is even awash with what they need to do. The court will be confused. The court sometimes will send the litigating person to go home and seek legal advice and return back. The matter is adjourned because the court could not comprehend what the legal issues are. And because when the legal issues are not well comprehended, if you shed all the tears you need, the court cannot assist you. The court can only assist those who present actionable matters before them and also raise the issues properly before them for trial, for determination. So if you have not raised these issues competently, properly, that in such a way that it comes between the ambience of the law, it comes between the jurisdiction of the court to determine, then it's wrong. Some of you also, when you go to employment tribunals, because when you lodge it sometimes, you get a response from the employment tribunal saying, all right, your claim has been accepted. That doesn't necessarily mean that you have a claim. It's when you now, the case is listed to say, give us the issues. What are the issues here? And you find out that you cannot comprehend the issues, especially when a case management hearing is scheduled. Those case management hearings to streamline the issues. Sometimes if you have 5 claims going on, you could see that during case management hearing, they are stripped down to only 2, or stripped down to 1. At some time, there's nothing to determine upon. So why would you do that? Especially if you really do have a case in sexual discrimination matters and other employment matters cases that you may have. You could see that some of you will run on one particular area of a claim, not knowing that your circumstances actually fit perfectly well and enough evidence for another claim, which stands 100% chances better than the one you think in your head that you stand a chance on. And that is why task next solicitors will guide you. Restore your self-worth as a female, as a male, and also restore your capacity and your competence, which you know you have, but you have been discriminated upon as a result of your sex or as a result of your orientation, whatever it is, and you have been reduced down and you've not been acknowledged of the fact that you may deserve some accolades based on your competence. Because if you're an employee and you're doing your very best, achieving result, but you've been discriminated upon, we're sort of giving you accolades for the giant strides you've made with the employer or in the workplace, but rather you have been talked down upon, you have been subtracted, you have been, in such a way discriminated upon, or in some circumstances harassed, even while you're doing the job, based on your sexual orientation or based on your sex. So as a result of that, you feel that it is not a good place, because when you receive some situations and it indicts and affects your self-worth, this is where, some people slide down into depression. When they wake up to go to work and they feel really depressed, that they're not happy to go to work. When they feel that whatever manner of things they do at the place of work will not be sufficed to be anything reasonable or will not be appreciated by the employers, or the work environment is toxic for them in such a way that because of their sexual orientation or sexual inclination, because they're male or female, or the management is not taking them serious, and they're just being allowed there. Now, that may not affect your salary or your wages, but you feel and you know that you have been, discriminated upon. And this discrimination is coming because of your sex. So if you know anybody who's watching this program, and you know someone who's complained to you about the sexual discrimination going on in the place of work, when I mean this, I'm not talking about place of work is place of work, whether it's a charity place of work, which means it's non-profitable organization, or whether it's a profit-oriented organization, whether it's a 2-man business, whether it's a 3-man business, whether it's a family business, whether it has also moved to a national, local business, and then it transcends up to a multinational business. And also a multinational business that they have branches all over the world. London, UK, or whatever may be their only branch or their headquarters, with also branches scattered all over the world, in all part of Africa, Asia, America, the rest of them. These are all employment. They're all called employment and also workplaces, whatever it is. As long as that work is registered, is recognized by the laws of the country where they operate. Once that is being recognized as a business, and that company pays corporation tax or whatever it is tax, or regulated, some of them that are sole traders and they have employees as well, this also affects them, whether they are one-person man business or two-man business, as long as the regulators have approved them to operate. Even if they're not approved to operate, especially those partisans who are trading with themselves and their family, and they are bringing one or two persons in there in the cost of their business, whether they are regulated by their trades or whether they are registered by the Company Act or by Company House or in the Company House, or whether or not, as long as they're carrying on business and they're making profits, they will categorize as workplace. And so once a sexual discrimination event or circumstance is raised by any of these employees, self-employed, consultants with them, these are all constitutes what I mean to be termed as sex discrimination or sexual harassment. These will come to fore and to play the part whereby you would know clearly that you've been discriminated upon. Tax Maddox Solicitors stands with you shoulder to shoulder. We'll stand with you to watch your back and watch your front and by your sides to make sure that any information and anything at all that you may need to know about your right. Remember, it's about your rights. It's not about vendetta. It is not about malicious claim, because the court and the tribunal knows where a malicious claim has been brought. The employer knows when a malicious complaint has been filed. And the employer will deal with it and maybe dismiss it as fictitious claim, a malicious claim. So Tax Maddox Solicitors will sift all that out and project the claim that is reasonable and is rightfully yours. Once that comes before us, we take it in recompense. We take it in all perspective and address issues with you. Ladies and gentlemen, I've been talking about employment matter, and my topic today I've been drilling on is sex discrimination updates. Ladies and gentlemen, the telephone lines are on there. Contact details are on there. Contact us, visit us, and take proper advice. Deal with it from the very beginning, which is that complaint from the beginning, and we will write it up to the tribunal, and you will show best to success. Time cannot permit me to go further. But I will say, if you are going through this, your words, whoever, come to Tax Maddox Solicitors, and we will sort you out. Till next time I come your way, I remain Justice Madforo, your preferred favorite solicitor, and this firm, Tax Maddox Solicitors, your preferred firm. God bless you.
Tice Maddox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist field. Tice Maddox Solicitors. Try us. We are professional.